So welcome everybody to our webinar, and we're going to be talking about how to recognize and address the undervaluation of homes in minority communities and how to combat appraisal discrimination. First off, quick little ground rules. Webinar is being recorded. We'll be posting it onto YouTube along with the slides, so you get an opportunity to see that. This webinar, of course, gives only general information. If you need specific advice or assistance as a particular claim or issue, please contact our office. Please make sure you put your Q&A into the Q&A, not the chat. I have them both open, the Q&A and the chat, so I'll be able to see what you post regardless. Again, it will be posted on our website under videos, services, and resources. And I'm going to also post a PowerPoint, and there's other videos and webinars, conferences that are also listed there. Thank you again for Mishta for sponsoring this webinar. Questions are always welcome. Please, again, use the Q&A, not the chat. So here's what we're going to be covering. Is on part one, we're going to do just introduction and background, the importance of home ownership, why it matters so much about appraisal practices, and how homes in minority communities can be often devalued, and evidence that there's a racial bias driving a significant portion of the devaluations and the challenges from an enforcement standpoint. That theme will kind of run through a lot of what we talk about today. Part two, we're going to look at the laws and legal theories that apply in appraisal discrimination cases. What are the fair lending laws, or the major ones that apply, and what are theories of liability, standard that you see in other kinds of discrimination cases, disparate treatment, and it can involve direct evidence or indirect circumstantial evidence, and disparate impact. And we're not going to just focus on those theories generally, but look at those in the context of how they apply in an appraisal discrimination case. And then we're going to look at ways to gather evidence of appraisal discrimination using HMDA data. We'll try HMDA data, and we'll look at loan level data and what the guidance to do a comparable file analysis. So this is going to be kind of practical. It's not a repeat of other appraisal discrimination presentations, whatever. I'm not going to get into historical background. I'm not going to summarize the appraisal enforcement process and all of that. It's really practical nuts and bolts of how you can establish and what kind of evidence that you gather to establish that there's been discrimination in the appraisal process. So we're going to do in the context of a couple case studies. In the first one, you may have seen this one. It got a lot of attention, deservedly so. Miss Duffy got the idea to remove any indication of the race from her home based on a New York Times article. There's others, other reports. I think MSNBC had one as well. So basically, they call it whitewashed her home, removed anything that would indicate her race. And then she had a white friend stand in for her on her third appraisal, and the value of her home doubled. Here's a quick scenario of what occurred for Miss Duffy. In 2017, again, we're going to take these case studies and apply them to the legal theories and kind of analyze it in a systematic way. But in 2017, she bought the home in Indianapolis for $100,000. Property values had increased, throughout the nation. She anticipated an increase in her value of her home in spring 2020 due to increase in the real estate market. And she also did some renovations on her home. And she's a Black female, lived in a historically Black neighborhood. In her first refinance attempt, she applied with Cityside for a lower interest rate. Here's Appraisal Inc. conducted the appraisal. In April 2020, the home appraised at just $125,000. She then bought a market analysis for the home, probably from a real estate agent, showing possible list price of $187,000. She forwarded to Cityside for reconsideration. Cityside refused to reconsider the appraised value. Then she did a second refinance attempt with her existing lender, Freedom Mortgage, and Freedom Mortgage retained Appraisal Network to conduct the appraisal. This time it was lower, just $110,000 with a $96,000 cash out valuation. She again challenged it, gave the market analysis to Freedom Mortgage. Freedom Mortgage refused to reconsider the appraised value. So a few months later, she let her credit kind of repair from the hits on it. So she contacted a new lender, and this time she did what we'd call a self-test. She didn't put down her race or gender in the refinance application. The only interaction she had with the appraiser consisted of emails and no phone calls, nothing that where someone could indicate what her race or that she's a woman. Then she removed photos of herself and her family, or any arts, object, book collections, anything that would indicate her race. And she had a white friend pose as her brother to meet the appraiser. In November 2020, the home appraised at $259,000. Pretty significant. In the second case study, this is a Detroit complaint. There was the sellers needed to sell their home and relocate for medical reasons. They entered into a contract to sell their co-op property for $177,000. The bank appraisal came in at just $77,000. Contract was canceled after the sellers and the buyers could not reach an agreement for a lower purchase price, somewhere between $177,000 and the $177,000 original purchase agreement amount and $87,000 the bank's appraised valuation of the property. And it was really closer to $87,000, something like $110,000 or something like that. Then they had an independent appraisal. It came in at $255,000, about 290% higher valuation. And they saw an MSNBC report of a similar case, so they submit a complaint with our office. Now, a couple facts: the property is located in a cooperative complex. There's two apartment complexes located across the street from the other. We'll call theirs cooperative A. Across the street would be cooperative B. The appraiser refused to consider comparable sales located directly across the street. And they were similar in terms of square footage, amenities, so forth and so on. There's slightly better architectural design in cooperative B. Historically, the board of cooperative A did not allow financing. So the only way you could purchase a co-op in cooperative A was through cash purchase. And that would, of course, result in lower sale prices for the homes. In late 2019, however, the board for cooperative A agreed to permit cooperative share lending. And they put it this way, quote, allowing shareholders to price their memberships at fair market value, close quote. Now, financing was always available for sales for cooperative B. Cooperative A is located as the demographics. Cooperative A is located as census block group that is 92.5% Black. Cooperative B is located in a census block group that is 61% Black. So there's about a 30% differential in the demographics between the two co-ops. The appraiser and lender responded to the complaint. The appraiser relied on comparable sales in cooperative A beyond 12 months. So he restricted the comparables to cooperative A. And he said that cooperative B is a different co-op that has historically supported values that are 2 to 3 times higher than in the seller's cooperative A complex. He also provided an MLS printout and the cooperative sales in the complex since 2003. The lender's chief appraiser agreed with the $87,000 valuation, also stated he was, quote, cognizant of the significant developments in the Detroit area as it continues to emerge from the financial crisis of a decade ago. So they went pretty far back in time. Those are our two case studies. So we're going to cover just a brief background, importance of home ownership, the valuation of homes in minority communities, and then the racial bias driving portion of the evaluations, and the significant challenges from an enforcement standpoint from a challenging appraisal discrimination. So how important is home ownership? Very. And this is the Federal Reserve Bulletin. Federal Reserve has a survey of consumer finances, and it shows median and mean net worth. The median net worth for owner versus rental households, the median net worth is $246,000, roughly $250,000 to just between $5,000 and $6,000. That's the median net worth. The average net worth is even more pronounced. There's some high value homes involved here. In 2016 to 2019, roughly $1 million mean assets, average assets for a homeowner household in comparison to just around $95,000, $96,000 for a rental household. You see the huge variation. We obviously want to consider, and anything we can do to encourage home ownership is a good thing. When homes are devalued, that certainly has an impact on home ownership. And net worth by race, you can see the large discrepancies that the median and net and mean net worth the disparities are just stunning between white or non-Hispanic households. Second would be multiple race households. But if you look at Black and Hispanic households, their net worth are very low. And that's why home ownership is so important, because many of the minority groups do not have low percentage of home ownership. And there's evidence that a racial bias driving significant portion of the devaluations. This has become a well-known study, Freddie Mac. Freddie Mac went through millions of appraisals that were submitted. I don't have the dates here. I want to say, I hate to use my memory, but I'll do it. From roughly, I think, 2015 to 2020, it's about a 5-year period. And they took, I think it was over 10 million, like 11 million appraisals. So what the Freddie Mac study did is it took appraisals where the appraisers limited to appraisers that had done appraisals in majority non-minority communities and majority minority communities so that they could do a comparison. So that got it down to 21,058 appraisers who submitted appraisal reports in both Black and white majority communities. 934 were sufficient to have statistics to perform a t-test, basically. So the t-test of those 934 appraisers showed that there was significant appraisal gaps, 54% at a 5% or 0.05 level of significance, but a stunning 31% had statistically significant differences in appraisal gaps between Black and white communities at a 0.01 level of significance. So this shows that it's a large number of appraisers that 31%, I think it's a good number, that have significant, how I put it, discrepancies. Like they're more likely basically to come in below the contract price in majority Black communities as opposed to majority white communities. And they found similar appraisal gap in majority Hispanic communities in comparison to majority white communities or white tracts. And there it was at 5% significant level was 47%, very high there, and 27% at the 0.01 level of significance. And the bottom line is this: these results suggest that a large portion of appraisers who performed enough appraisals in both Black and white tracts and Black, Latino and white tracts exhibit statistically significant Black versus white gaps or Latino versus white gaps. That's a problem. What's the net effect of it? It ends up having a devaluation of Black homes. If you look at this map here, it shows devaluation. These are areas in majority Black neighborhoods where they're worth less. To tie it into our cases, here's Indianapolis, like case study 1. If you look at it, the median home value in majority Black neighborhoods, 94,000. And the estimated median home value in majority Black neighborhoods in the absence of devaluation, you would expect it to be 112,000. And you can see the average devaluation of homes in minority Black neighborhoods is 17.6%. So there's also dissimilarity index. The dissimilarity index shows that it ranges between 0, perfect integration, and 100, which would be perfect segregation, and it's 0.61. Once you get over 50%, it becomes considered a segregated neighborhood. You can see that there's a problem with the devaluation of Black homes in the Indianapolis community. Did the same thing for Detroit. Took it from the, I believe this was, Brookings Institution, from their website. Look at Detroit, Dearborn Warren, MSA. It showed that the median home value majority Black neighborhoods was 62,000, without, in the absence of devaluation, it should be 90,000. The average devaluation is 36.9%. The dissimilar index is even higher, 0.72. That's pretty significant, right? And look at at the bottom underneath the small print under dissimilarity index. It says 72% of the white population would need to move to a different neighborhood for the white and black population to be distributed evenly. That's what I'm saying. You know, when you get over 50% in that, you know, it's a problem that needs to be addressed. At times, I think this understates it. For example, Southfield is majority black and it looks integrated, except that if you then go a little bit further and look at school district, then you'll see that there's actually a split within that city. So even within cities, you have splits. Right? We're a long way from the integration we need to have. Not to talk about it generally, but to say this impacts the appraisal practices. So what would the devaluation of black homes? You can see Detroit, Warren, Dearborn, MSA, 36.9% difference, or $28,000 absolute price difference in the homes. This is coming back to the Freddie Mac study. And here's to drill right down. It looked at it this way. And if you look basically in the graph, 7.4% appraisals for white applicants receive a valuation below the contract price. Why the contract price? Well, it's a proxy for what a reasonable buyer and seller would put a valuation on their home. That's what they consider. It's a bargain for. Often they'll have real estate agents or realtors assisting them. But yet, you know, it's 7.4% of the appraisals come in below contract price for white applicants. When you go to Hispanic neighborhoods, 50 to 100% Hispanic, they received a valuation. The home gets appraised below the contract price 15.4% of the time, and black property tracks it's 12.5% of the time. So the gap between black and white for Latinos, it's 8%. For black and white, it's 5.2%. That's significant. That's a large variation. So what's been done to challenge this? So far, not aware of any successful trials in appraisal discrimination cases. The two cases that went to trial were unsuccessful. Hansen is one case, we'll talk about that a little bit, and Thomas versus Federal Savings Bank of Indiana. Those are two cases where it actually went to a trial. I think both were bench trials. And Cartwright versus American Savings Loan Association. The appraiser used a cost approach in computing the appraisal due to the claimed absence of comparable sales. Now, due to extensive media coverage, there's numerous appraisal cases that are pending in court. There's numerous ones that are pretending getting back to the court ones. Notable appraisal case just recently settled for a non-disclosed amount. That's the Tate Austin versus Miller case. And the DOJ filed a helpful statement of interest in the case as well. On the administrative side, there's numerous administrative complaints that are pending with HUD, with state and local agencies. But at this point, I'm not aware of any charge of discrimination get issued after HUD or a state agency finds cause in appraisal discrimination, then they'll issue a charge. I'm not aware of any charges that have been filed. I'm aware of two conciliation agreements. The first one is the name of the complaint. The name is withheld, but it's against JP Morgan Chase. That was a $58,000 recovery to the complainant. It required Chase to adopt a reconsideration of value process and mandatory training. It's a very, very good conciliation agreement. Thompson versus Stewart, not so good. It had some training in review of their fair housing policy, but simply provided a complainant $1,000 that the complainant could then use to get a new appraisal, an amount not over than $1,000. So it's not great. I don't know the specifics. Thompson versus Stewart case, along with Chase, I suppose. But the Thompson versus Stewart case really conciliated very early on before there was a lot of factual investigation. So it shows that there's a lacking of effective enforcement challenges when it comes to appraisal discrimination cases. So what can we do about it? Let's go through the laws and legal theories that can apply in appraisal discrimination cases. So what are the fair lending laws and what are the theories of liabilities that can be used? Well, we're going to look at the laws and theories of liabilities. We're also going to examine in the context of our two case studies. First, we hear fair lending mentioned a lot, even though one may say, use the term fair lending. There's no real one specific fair lending law or fair lending law. It's just an umbrella term or a general term that refers to all federal and state laws that prohibit discrimination, as well as laws that prohibit or discourage unfair predatory loans that unfortunately target or adversely impact minority communities. So what are the major fair lending laws? Someone said, can we get a copy of the PowerPoint sent to our email? Absolutely. I will post it on YouTube and you just click on it and you'll get a copy that way. But either way, any way that you want it, just send an email to info@fairhousingdetroit.org and I will get that out to you. Absolutely. This is a large file, so what I'll do is I'll put it in Google Drive and send you a link. So what are the major fair lending laws? First, the Fair Housing Act. It only applies to residential properties. It has 7 protected class categories. HUD's implementing regulation as to appraisal practices found at 24 CFR 100.135. We'll see that in a second. Equal Credit Opportunity Act covers residential and commercial properties. It doesn't include disability, but it adds marital status and age, and also receipt of income derived from any public assistance program. Now, the notes on these, there's an election of remedies provision in Equal Credit Opportunity Act. You can't sue under both state law and Equal Credit Opportunity Act. You're limited in recovery. It caps punitive damages at $10,000. The Fair Housing Act and Civil Rights Acts of 1866 and 70 do not cap punitive damages for housing discrimination cases. And there's a defense for good faith reliance on official interpretations by the Consumer Financial Protection Bureau, or CFPB. I can't say enough about that. If you have any question concerning the Equal Credit Opportunity Act, please review the official interpretations. I had a call from an attorney who had a case where the borrowers were turned down. The family received foster care income. The lender would not consider the foster care income. It was about $2,100 a month, and they turned them down because of their debt ratios. Had they considered the foster care income, it would be sufficient. It's not clear under Equal Credit Opportunity Act. If you look at it, public assistance program, if foster care income is a public assistance program, it's implemented by Regulation B. When it comes to Equal Credit Opportunity Act, it's not real clear under Regulation B. However, the staff commentary explains what is meant by public assistance program, which clearly would cover foster care income. So it's really important to look at that official interpretations. Another thing about it is a defense. If a lender follows the official staff interpretations, that can be a defense to liability. It's a good faith defense to it. So it's very, very important to look at that, not just the Equal Credit Opportunity Act, not just Regulation B. Really better to start backwards with the official interpretations. There's also a 5-year limitation period nationwide for claims under Equal Credit Opportunity Act. Long statute of limitations period. The Civil Rights Act of 1866 and 70 cover residential and commercial. The characteristics or the protected class categories, race, including white, color, ancestry, ethnic characteristics. Doesn't cover, quote, national origin, strictly speaking. And it requires proof of intentional discrimination. There's no disparate impact claims allowed under sections 1981 and 1982. And in the state civil rights laws, in Michigan, we have Elliott Larson and Michigan Persons with Disabilities Civil Rights Act. I've referenced the sections that prohibit discrimination in appraisal practices. So those are the various civil rights laws, standard, apply. The little twist, though, is that the Equal Credit Opportunity Act, where you see in a minute, is real crucial tool when it comes to lending discriminations generally, and specifically when it comes to appraisal practices. So the Fair Housing Act, Section 805 addresses it, and under 805, unlawful to deny loans in whole or part, or to discriminate against in the fixing of the amount, interest rate, duration, or other terms or conditions of such loan because of the race, color, religion, national origin of the person associated with them, and so forth. So when the Fair Housing Act got originally passed, it was Title 8, Civil Rights Act of 1968, Section 805, doesn't say anything about appraisal practices. It's just general prohibition on lending discrimination. In the congressional record, I have it all online. I did a word search in that. It only came up one place, believe it or not. It was not on anybody's radar screen, but the remarks of Senator Mondale. He said FHA's conservative mortgage appraisal praising policies by stressing stability within a social and racial context reinforced the division between the Black core and white suburbia. Good point. In the Fair Housing Act got amended in 1988, and this is where Congress put a separate section called Discrimination in Residential Real Estate Related Transactions. And under Part B, definition is used in this section. The term residential real estate related transaction means any of the following. In subsection 2B2, the selling, brokering, or appraising of residential real property. It also added under 805C or 3605C an appraisal exemption. Nothing in this title prohibits a person engaged in the business of furnishing appraisals of real property to take into consideration factors other than race, color, religion, national origin, sex, handicap, or familial status. HUD then, I don't know how many months, 24 months or so, required to come up with regulations, implement the 1988 amendments, and HUD's 24 CFR 100.135 is the regulation that deals with appraisal practices. It actually drew on the text of both the original text of 805 in 1968 and the 1988 amendments. And it says it's unlawful to discriminate in appraising residential property based on race, color, religion, sex, handicap, familial status, or national origin. And it defines what a term appraisal means in Part B. And C, nothing in this section is Part C of the regulation tracks Part C of Section 805 and so forth. Then it lists practices which are unlawful. So it's generally, right, pretty general in terms of prohibits discrimination when it comes to appraisal practice. There's not much to be said there. The legislative history really only dealt with the appraisal exemption, and the main legislative history for the 1988 amendments to the Fair Housing Act is found in the House report. And this section clarifies that appraisers, the appraisal exemption in 805C clarifies that appraisers may take into consideration relevant and non-discriminatory factors when making appraisals. But again, they can't discriminate based on race, color, religion, national origin, sex, handicap, or familial status. And there are additional views or dissenting views in the House report. A group of, starting with Representative Hyde, I offered an amendment which would have deleted the real estate appraisals from the bill's peer review, basically wanted appraisers to be completely exempted from liability under the Fair Housing Act. Unfortunately, his amendment was never acted on, so he puts it. Edwards offered a substitute amendment which instructs appraisers to take into consideration or permits them to take into consideration factors other than race, color, religion, national origin, sex, and so forth. Under the Edwards substitute, appraisers must report on the market value of a piece of property without discussing such relevant factors, whether it's a church or synagogue in a neighborhood or whether the property is located in a certain ethnic-oriented area. So there was some debate when it came to the appraisal exemption. And so that's where we are in terms of the Fair Housing Act. Equal Credit Opportunity Act governs not all aspects of lending transaction, the rules for applications, loan documents, notice to applicants, providing copies of appraisals and so forth. It's really the main It's the main law when it comes to lending. That's how banks will view it. That's how lending institutions will view it. And I referenced the official staff interpretation, which I mentioned earlier, that is a good faith defense to liability under Equal Credit Opportunity Act. And the recommended approach is any question about the Equal Credit Opportunity Act, start backwards, review the official staff interpretations, review Regulation B, and then review the text of the Equal Credit Opportunity Act. The main thing about appraisals on the Equal Credit Opportunity Act is that it requires that copies of appraisal reports be given to all applicants. My 2 cents, I'd like to see copies of those appraisal reports given to both the buyers and the sellers. I think they have an interest in it as well. And here's, if you look at official staff interpretations, I took quoted here, the official staff interpretations on the rules for providing appraisals and valuations. If you notice at the bottom, it talks about providing a copy of a automated valuation report. Talks about providing a copy of a valuation report, automated value report, and that has to be provided as well. So it gives a little bit more information than what you would get by simply looking at the Equal Credit Opportunity Act and its regulation. So here's an example of a case showing the lender's violation of the Equal Credit Opportunity Act. There's a Cartwright case. And here's what they said. The district court said the application, because of lack of communication, inconsistent positions taken by Ms. Cartwright, the plaintiff, and total misunderstanding, went into abeyance and into limbo. Therefore, the plaintiff had not proved that the loan was rejected. And the Court of Appeals approach did the same thing. It accepted that. I'll read the bottom part. Green's comment that the 1980 loan application died a natural death reinforces the trial court's finding that the application was never rejected, but went into abeyance and limbo, while the bank was waiting for Ms. Cartwright to work out her personal problems and forward the comparable housing information. That's not correct. Under the Equal Credit Opportunity Act, if it's an incomplete application, the bank is required to notify the borrower of any information that's needed to complete the application. Can't just let the loan application die a natural death. So if you look at it in that, again, it's not correct, but it's not presented, that no one looked at the equal Regulation B, Equal Credit Opportunity Act regulations to see how the procedure should have worked. And I was taking a step further. The bank knew full well about those regulations. They know those intimately well, and they should have followed it. Another important thing that the Equal Credit Opportunity Act does, it requires that a decision be made within 30 days of a completed application. If the loan is denied or not approved on the conditions requested, there's a notice, the statement of denial, termination, or change has to be mailed to or sent to the borrower in writing, explaining each of the reasons why the credit was not extended in the way that it was requested. That has to be accurate. Equal Credit Opportunity Act also has a 24-month retention. They have to retain the file for 24 months. So there's a lot of regulations that have to do with the Equal Credit Opportunity Act that need to be complied with. That's very important to pay attention to in looking at any kind of lending discrimination or appraisal discrimination case. And here's information again from the Equal Credit Opportunity Act. There are automated valuation models. Again, they're not used in mortgage underwriting, but they're informational purposes. It can be used by underwriters in reviewing an appraisal. It can be used in refinance and loan modifications or foreclosure proceedings, or quality control processes. The leading one is Freddie Mac's AVM, named Home Value Explorer, HVE. And that's one that can be used whether we know it or not. We are using these. For example, if you turn on the computer and you look at your property or look at a property, you'll see a Zillow report. That's an automated valuation model. iBuyer, Want to Sell Now, they also use those models. Advantages, they save a lot of time and expense by removing the need to have an appraiser come out to perform an assessment. It's used as a starting point by real estate agents and lenders to evaluate properties. It eliminates potential for human error and bias. True, but it's only as good as the algorithms and accurate the algorithms. And it's dependent upon a large amount of high quality data, but it doesn't, again, factor into consideration of the property. A real appraisal means that appraiser would have to come out, physically inspect the interior of a home to really do a full valuation of the property. Here's an example of an HVE report. You can kind of see how that looks. This is what gets generated through Freddie Mac. So what are legal theories? 2, disparate treatment, disparate impact. Disparate treatment more often gets alleged. Often it requires either direct or indirect circumstantial proof of intent, discriminatory intent against one or more protected class members. It can be inferred by similarly situated people receiving differential treatment can be sufficient to establish disparate treatment. Disparate impact does not require proof of intent. It means just a facially neutral policy that has a disproportionate adverse effect on members of a protected class, typically statistical evidence. So these are the legal theories that apply to appraisal discrimination cases. Before getting to the legal theories, it's really important to differentiate the 3 categories of lending appraisal discrimination cases, and they have different proof elements. First one I call it traditional discrimination based on protected class status, then redlining and reverse redlining. Please note, a case can involve more than one category. It can have traditional discrimination with redlining. It can have reverse redlining and traditional discrimination. We're going to break those down in a second. So we're going to see those various 3 categories when it comes to disparate treatment and disparate impact. So first, we're going to look at disparate treatment and direct evidence. Again, direct evidence should be rare in appraisal discrimination cases. There's federal, I have some regulations quoting it on the left-hand side. This is regulation from the Control of the Currency, Department of Treasury, Federal Reserve, FDIC, National Credit Union Association. And it says the requirements for all federally related transactions, and they must conform with Uniform Standards of Professional Appraisal Practice, or UPAP standards. Those are nationwide standards for appraisal practices. Be written and contain sufficient information to support the institution's decision to engage in a transaction. So it puts the requirement on the lender to make sure that they're using an acceptable appraisal. Lending regulations historically prohibited lenders from relying on appraisal, which they know or reasonably should know, quote, is discriminatory on the basis of age or location of the dwelling, or is discriminatory per se in effect under the Fair Housing Act, the Equal Credit Opportunity Act. And of course, some say, well, the Uniform Appraisal Report that the appraisers use show, right, it contains a certification that on the form, race and the racial composition of the neighborhood are not appraisal factors. They also certify that they did not base their analysis or opinion of value based on protected class status of either the prospective owners or occupants of the property, or the present ownership or occupies, or where the property is located. And so that is, but again, if making something unlawful to do stopped the practice from ever occurring, we would solve all our problems with a law. Laws don't solve the problems. People still discriminate, unfortunately. And in Cartwright, direct evidence, their direct claim was based on direct evidence. The lender's vice president charged with mortgage loan responsibility is claimed to have told the plaintiffs that the urban rural area could not afford their proposed residence. The court found that evidence insufficient based on all the evidence in the case, including a testimony by a vice president. He expressed concern that the property and proposed residence would not retain an adequate value over the term of the loan, thereby putting American savings at risk. We're going to look at another case in a second. And in Thomas, First Federal Savings Bank, plaintiff testified that the lender's in-house and chief appraiser told one of the plaintiffs, this house would have been worth $100,000 if it were located anywhere else. The courts said it's not discrimination. It just referred to the over improved condition of the Thomas's home when compared with other houses in the areas. So where do you get direct evidence? look at other sources, really. I have 4 of them that I think give some evidence. First one is reducing valuation bias by addressing appraiser and property valuation commentary. This is from the Federal Housing Finance Agency, FHFA, in December 2021. Fannie Mae has an appraiser update. Fannie Mae single family guidelines also have some guidance on that. And LandSafe circular, fair lending valuation and reporting practice. Let's look at those. So the first one is reducing, this is one from Broadnex and Wiley, reducing valuation bias. So what they did is they went through, they searched of, come back to this again, I want to get it, FHFA, Housing Finance Agency. They went through their database, searched through millions of appraisals, and they did keyword search that result in thousands of potential race-related flags. Right, many instances of keywords to be false positives, but the following are examples of what they found. Again, the standard is this: the racial and ethnic composition of neighborhood should never be a factor that influences the valuation of a home. However, they said our observation of appraisal suggests that racial and ethnic compositions of a neighborhood are still sometimes included in commentary. This is the part of the appraisal form where the appraiser can put comments down, clearly indicating the writer thought it was important to establishing value. These are the examples, and they're pretty bad. In some appraisals, talk about the percentage of the racial and ethnic makeup of the area. Foreign birthplaces of residents noted as part of the neighborhood descriptions. The language spoken in an area. Amenities specifically geared to race, ethnic, or religious group. Rising house prices were because of gentrification. A town was described as having a Black race population above state average, noting that Koreatown is considered highly diverse ethnically, and number of foreign-born persons was considered high compared to the city as a whole. You can see the kind of language that the word search showed that were typed into appraisal reports. This is taking into consideration protected class status when it comes to valuations of homes. Another one, Fannie Mae in June 2021 did an appraiser update, and it said that while appraisers may not intentionally factor prohibited basis into the valuation, some words or phrases can undermine the credibility of the appraisers. And here's some examples: problematic phrases. Different families have different needs, which change what they will see as desirables: crime-ridden area, affordable neighborhood, integrated community, and they have what should be an objective description. Instead of desirable neighborhood, list the neighborhood's features, amenities that potential buyers would find of value. Newly updated neighborhood swimming pool, crime-ridden area, and they list the crime objective description of that would be the crime rate in this area is X% and allows the reader to make their own judgment about the potential impact of crime. I don't agree with that. If an appraiser is looking at the crime area in just minority communities, but not looking at the crime rate in non-minority communities, right? That would be discriminatory. Better yet, leave the crime rate out of it. People on their own can get a sense of crime rate that's probably factored into the price of the home or offer on the home anyways. Why further estimate that, or why further draw that as a factor in evaluation of a home on an appraisal? Shouldn't even be there, right? And so forth. So problematic, that's kind of a weak way of putting it, right? It could potentially discriminatory. Fannie Mae single family guidelines are another source of what would be unacceptable appraisal practice. Again, I'm looking for direct evidence of what would be discrimination in the appraisal practices. Again, you can't partially or fully come up with a valuation based on sex, race, color, religion, disability, national origin, familial status, or any reference to a protected class of the prospective owners, sellers, neighborhood, community, right? A factor in this is use of unsupported assumptions, interjections of personal opinions, or perceptions about the valuation process. Here would be one: pride of ownership, no pride of ownership, lack of pride or ownership, good neighborhood, crime-ridden area, desirable, undesirable neighborhood or location, right? Those are subjective. It's supposed to be an objective process based on the comparable properties, comparable sales. Land safe, they're circular. Really, they begin by quoting or citing to the Fannie Mae guidelines with the pride of ownership, no pride of ownership and so forth, desirable, undesirable neighborhood or location. They also give examples that kind of highlight those. And you can see how it looks like in a discriminatory type appraisal that could be challenged as discriminatory. Subject appears to be in good condition as located in a good neighborhood close to school, shopping, and the park. Do you think that kind of language is there in all appraisals or just some, right? That's where the discrimination comes in. And what you'd want to do is get all the appraisals from that appraiser and see where those kinds of statements are made. Sales comparable 1, we reference a desirable location. And you can see going a little bit further, with no student theme there at the bottom, however, does not appear in a well-maintained state with pride of ownership, meaning what? There's not really pride of ownership here. That's suspect. I think these are some factors that would lend to finding discrimination with direct evidence. This case is very concerning, Hansen case. And look at what it says here. The plaintiff, Hansen, found evidence that several VA appraisal reports concerning McGregor property referred to economic depression, changes in the neighborhood, and lack of pride of ownership, all which their expert testified indicated racial considerations. In response, the Veterans Administration had 5 Houston appraisers examine the appraisals and testified that these phrases did not have racial connotations. They testified that the appraised values appeared reasonable and that they're not aware of any Houston appraiser who used racial consideration in their appraisals. It's like they really circled the wagons, didn't they? Emphasizing that such consideration would be unethical. Additionally, VA appraisal forms require the appraiser certified to not take race into account in the appraisal. That's right on the form. Doesn't mean someone is following that or not. We are persuaded the district court was entitled to accept the testimony of the VA experts over that of the appellant's experts and so forth. So basically, it had to be a credibility determination because the district court found in favor of the Veterans Administration experts, plaintiff loses. And appellants also contend the district court failed to properly appreciate the significance of the evidence that VA appraisal of McGregor property are riddled with errors such as understating the size of home or overstating its age. Target D's numerous errors always tended to justify a low appraisal, considered collectively create an inference of racial bias. The district court did not err and characterize the independent instance of human error, which did not prove discriminatory intent. So again, I think that's just because that's how the district judge viewed the evidence in the case. But I think if there's changes in the neighborhood and lack of pride of ownership, I think if you drill down in terms of what that would consist of, what are the changes in the neighborhood? What changes are in the neighborhood? Black people coming in, Hispanic coming in, low-income developments are being made, right? Lack of pride of ownership, what does that mean? Right? Those are one step away from racial, national origin, protected class status. So to go to the Duffy's questions, does Duffy's situation present one or more of the following: traditional discrimination, redlining, reverse redlining, and is there direct evidence of appraisal discrimination? And if I look at this one, she said that she had to whitewash her home to come up with a fair valuation of her home. That makes it seem like the first 2 appraisals took into consideration her race, when she then had someone stand in and had no direct contact with the appraiser for the 3rd appraisal, where the appraiser on the 3rd appraisal would not be able to determine her race, then she received a better valuation. That looks like traditional discrimination. There's also redlining because she makes a point that her home was located in a predominantly Black community in Indianapolis, That's redlining. Reverse redlining, we're going to see is a little bit different. That's where areas are being targeted for unfair or predatory loans. Here, it was a straight up to now. It wasn't really a reverse redlining situation. So it's a mixed case of traditional discrimination and redlining. But leaving that aside, is there direct evidence of appraisal discrimination? In a report, news report, she said she wasn't sure what to think about the assigned value. She read the appraisal report, the wording in it just sent out red flags. Okay, looks like red flags. That's probably maybe something in the appraisal report looks like direct evidence of discrimination. It said there were comps within a half mile, but it said the quality of the construction of their homes were far more superior. She looked at the comps and pulled property cards. She said she thought the value is incorrect, noting that nearby neighborhoods include Ransom Place and Old North Side. If that's the case, what is the difference in those neighborhoods versus my neighborhood? That does not look sufficient to be direct evidence. That looks like this is a case of indirect circumstantial evidence. So I would say probably not reaching the level of direct evidence. Right? So, and that's how it is with many of the cases. So again, we'll look at proving disparate treatment by indirect circumstantial evidence. And this typically requires a prima facie case analysis. The prima facie case analysis approved by the Supreme Court in McDonnell Douglas Court versus Green for Title VII employment discrimination has been applied to Title VIII, which is the Fair Housing Act. And I have some cases cited there. In step one, the plaintiff has a burden of proof to establish applicable elements of a prima facie case, and meaning at first glance, establishing these elements gives rise to an inference of discrimination. Second step, if the plaintiff establishes a prima facie case, the burden of production, but not proof, shifts to the defendant to articulate one or more legitimate non-discriminatory reasons for the plaintiff's rejection, imposition of challenge terms, etc. Assuming the plaintiff or the defendant satisfies the burden of production in step two. On step three, the plaintiff then must present evidence rebutting each and every non-discriminatory justification, showing they're false and pretextual. Once that's done, it permits but does not require the ultimate decision maker to judge a jury to find the underlying motivation as discrimination. In that case, without any inference or anything else like that, the judge or jury considers all of the evidence in the case and decides whether or not discrimination has occurred. That's the McDonnell Douglas framework. For lending appraisal discrimination cases under the Fair Housing Act, sections 1981 and 1982, Equal Credit Opportunity Act, and even state law claims, pretty much most courts apply the McDonnell Douglas Title VII prima facie case approach. Establishing a violation of the Fair Housing Act will establish the Equal Credit Opportunity Act, sections 1981. The same legal standard applies to all of them. All federal courts of appeals, except for the Seventh Circuit, use the McDonnell Douglas formulation. I've cited those. The Seventh Circuit, however, in Lattimore, said that the McDonnell Douglas approach is not applicable in credit discrimination cases, except where there's a competitive situation between different borrowers. Rather, complainant must establish a prima facie case showing there's enough evidence, direct or circumstantial, of discrimination to create a triable issue. So that's what Lattimore said. And the Seventh Circuit in Swanson, it said that this was an appraisal case as well, Swanson versus Citibank. The Seventh Circuit said that the plaintiff survived a motion to dismiss, but would need more at the summary judgment stage. Summary judgment is where the evidence gets evaluated, the factual evidence gets established to decide whether or not the case can proceed to trial. But that the plaintiff would need more at the summary judgment stage than evidence of a discrepancy between appraisals. Just the mere fact that appraisals have different valuations are insufficient to show or to establish discrimination in appraisal practices. It takes something more. What is that more? Not told. We're not told by the Seventh Circuit. The Third Circuit has a slightly different approach in Anderson. The prima facie cases, plaintiff must show they belong to a protected class, applied for and qualified for credit that was available from the defendant, that their application was denied or that its approval was made subject to unreasonable or overly burdensome requirements, conditions, and some additional evidence exists to establish a causal nexus between the harm suffered and plaintiff's membership in a protected class. Now, in modifying as similarly situated, they requiring evidence of similarly situated individuals in the lending context would be overly burdensome because parties would likely have considerable difficulty determining which applicants are similarly situated. So that's a variation as well. But again, the Third Circuit does adopt McDonnell Douglas. Several courts have followed the Third Circuit's approach. All right, here's the nuts and bolts. On traditional discrimination, the prima facie case has these four elements: plaintiff member protected class, plaintiff applied for or qualified for a loan, lender rejected or otherwise failed to approve the application on favorable terms and conditions. The lender continued to approve loans and provide more favorable terms and conditions to a contrasting class of applicants with qualifications similar to those of the plaintiff. That's traditional. Redlining is a practice, you see this in appraisal cases where areas are what? It was an earlier practice where a lender on the basis of the ethnicity or race of a community would mark off red areas as poor risk areas. They would deny insurance companies or lenders would deny making loans in those areas. And the persons would receive adverse treatment regardless of their creditworthiness. And so redlining is excluding areas from lending activities. HUD's regulations specifically prohibit redlining under 100.201B. So what are the elements of a prima facie case of redlining? This is from Steptoe and Old West End. There's a split. The Seventh Circuit doesn't follow these cases. So two earlier district court decisions. This is the prima facie case. The housing sought to be secured is located in a minority community. The plaintiff applied for a loan to purchase the housing in the located minority neighborhood. And there can be variations on this. If it's a refinance loan, then instead of loan to purchase, it would be a refinance loan. Number three, an independent appraisal concluded the value of the house equal to sale price. Plaintiff was creditworthy and the loan was rejected. And that's evidence of the prima facie case when it comes to redlining. Now, the district court in Latimer distinguished Steptoe and Old West End. And so what the district court said, in the present case in Latimer, the district court said there's no evidence of the sort present Old West End and Steptoe. In Old West End and Steptoe, in Old West End, the purchase price was $78,000. The firm that prepared the mortgage application ordered an appraisal, and the appraisal noted valued the house at the sale price and noted the predominant value of the property in the area was $70,000. The firm forwarded the application along with the appraisal to the lender. The lender denied the loan application for $78,500. And the court found they made up a prima facie case of a FHA violation because of evidence that the defendant's alleged reason for denial was untrue, as well as the evidence of the lender's underwriting practices differ depending on the racial composition of the neighborhood. So you can see the appraiser valued the house at the sale price, but the lender still turned it down. Apparently because the prominent value of the property in the area was $70,000. In Steptoe, they found a house advertised at $129,900. The sellers agreed to accept $115,000. Plaintiffs applied for a loan. Defendant appraiser included the house was worth $115,000. The chief appraiser disagreed, ordered a new appraisal, which lower, and on the basis of which the application for $103,500 loan was denied. The court found inference of racially motivated behavior from the facts. Despite the downward revision of the appraisal, the defendant continued to carry the property on its comparable sales card as valued at $115,000. And the chief appraiser failed to follow the felon's policies regarding reappraisals and so forth, right? And there was a plaintiff's expert testified defendant's second appraisal was defective, and the plaintiffs offered statistical evidence supporting their theory that the defendant's lending practices resulted in a racially discriminatory effect in the neighborhood which the plaintiff sought to reside. And so the district court in Latimer found this case, the Latimer case, different than Old West End and Steptoe. And the evidence here is The uncontradicted evidence shows that his appraisals consistently supported mortgage loans for other African Americans and in the same neighborhood. We're going to come to that in a minute because Latimer is going to go into more, on appeal is going to go into more detail. So the Seventh Circuit in Latimer, again, rejected McDonnell Douglas, using it in credit discrimination, lending discrimination, appraisal discrimination cases. Although the Seventh Circuit doesn't cite Steptoe and Old West End, they rejected it. It said that they rejected the idea that plaintiff Latimer could survive the lender's summary judgment by showing that, quote, her house was in a minority neighborhood. An appraisal, but not necessarily the defendant's estimated value of the house to be at least equal to as great as a loan. The plaintiff was creditworthy, yet the loan was rejected. Well, that was obviously something based on Steptoe and Old West End. The Seventh Circuit rejected it. Comparative evidence. Latimer's proposed prima facie case, like the banks, lacks any comparison between the treatment of blacks and treatments of whites. We're going to deal with that. The way to meet this higher Latimer standing. And again, it's always open to the plaintiff in a credit discrimination case to show in a conventional way without relying on any special doctrines of burden shifting that there's enough evidence, direct or circumstantial, to create a triable issue. And they expressed displeasure with Latimer's decision to name the appraiser as a defendant. And the year that Latimer's application was turned down, the appraiser appraised the property of 69 blacks, and only 2 of their applications besides Latimer's were turned down, hardly suggesting that the appraiser is trying to discourage blacks from obtaining Citibank loans. So, you know, it's tough. And later decision by Seventh Circuit in Swanson, the panel in Swanson noted the plaintiff would need more at the summary judgment stage than evidence of discrepancy between appraisals. And Cartwright said addressing redlining claims in the context of the number of loans made in minority, not minority areas rather than appraisal practice. So the Seventh Circuit hasn't really given clear indication of what that evidence would be sufficient to bring a appraisal discrimination case. Reverse redlining is the opposite. It's a variation, whereas redlining involves denial or refusal to make a loan based on race and ethnicity of a residents of a particular area. Reverse redlining does the opposite. It targets or extends credit to neighborhoods or to a class of people typically living in the same neighborhood on terms less favorable than would have been extended to people outside a protected class. Like other kind of evidence, discrimination claims, reverse redlining can be established by direct or indirect circumstantial evidence. And again, rather than showing that the lender refused to engage in real estate transaction or loan transaction, right? It's just that the lender refused to do so on fair terms. A way to put it is this way, and these are the elements for reverse redlining. Plaintiff, a member of protected class. Plaintiff applied for and was qualified for a loan. The loan was provided on grossly unfavorable terms, and the lender or the defendant continued to provide loans to other applicants with similar qualifications, but on significantly more favorable terms. If it's shown that the lender intentionally targeted the complainant for unfair loan based on protected class membership, the complaint does not have to show that the lender provides loans on more favorable terms to others outside the protected class. Interesting thing about reverse redlining cases, most of the reverse redlining cases do the opposite. In the regular traditional discrimination or redlining, it's coming up with low appraised values to basically turn somebody down. When it comes to reverse redlining, it's often involved inflated appraisals, right? And you can look at it, undisclosed, the County of Cook case, undisclosed inflation of appraisal values of minority residents in order to support loan amounts to minority borrowers, further increasing the likelihood of delinquency under defaults under those loans. MT Mortgage Corp versus White, they inflated appraisals. And Barclay had a significant one, a whole group of borrowers, right, were targeted based on their race, and the appraisers were part of the fraud scheme or discriminatory scheme, and part of it was based on having inflated appraisals. So that's what you see in reverse redlining. So if I come to Duffy, you make it practical. For Duffy's situation, would you use traditional discrimination, redlining, or reverse redlining? Again, we're looking at indirect circumstantial evidence. Under traditional discrimination, is Duffy a member of protected class entitled to protection? Yes, to his minority. Did Duffy apply for and qualified for a refinance loan? Yes. Did the lender reject or otherwise fail to approve her refinance loan despite her qualifications? Yes. Did the lenders continue to approve refinance loans with respect to contrasting class of applicants with qualifications similar to those of Duffy? Don't know. We have to get that information. We'll talk about a way we can get that. So traditional discrimination kind of fits. How about redlining? Is Duffy's home for which she sought to be refinance loan located in minority neighborhood? Yes. Did she apply for a refinance loan for housing located in minority neighborhood? Yes. Did an independent appraisal conclude the value of a home equal to the refinance amount? Yes, the third appraisal did just that. Was she creditworthy? Looks like she weighed a little bit till her credit recovered from the earlier refinance loan application. So I would say yes to that one. And was her refinance loan application rejected? Certainly it was. So it would meet, the Steptoe, West End standard. Under the Seventh Circuit standard in Lattimore and Swanson, with evidence which you have to show beyond discrepancy in the appraisals. Not sure. It's a tough standard to meet. So we'll come back to this. And reverse redlining, is she a member of protected class? Did she apply for and qualify for a loan? Yeah. Was a refinance loan provided or offered on grossly unfavorable terms? No, it's just denied. Did the lender continue to provide loans to other applicants with qualifications similar to Duffy, but on significantly more favorable terms? No. Is it shown by direct evidence the lenders intentionally targeted Duffy for unfair loan based on her protected class membership? No. So really, I don't think reverse redlining fits for this Duffy situation. So she would have the elements that she would have for proving appraisal discrimination by indirect circumstantial evidence would be traditional discrimination and redlining. Redlining, she can meet under Steptoe, Old West End Association. Difficult under Lattimore or Swanson in the Seventh Circuit. So, and we're going to get into more specifics on how you're going to get this evidence to get over the threshold. So the second one is disparate impact. Requires proof of discriminatory effects or perpetuation of discrimination regardless of intent. This shows just a quick little summary of all the recent developments. It's been a lot. It's been a lot these 10 years. When it comes to disparate impact theory of liability, the long and short of it is you can look at the bookends. HUD's 2013 disparate impact regulation, 24 CFR 100.50. And if you go all the way to the right, March 13th, HUD has now reinstated the discriminatory effects standard, going right back to the original 2013 rule. The HUD proposed a 2020 disparate impact regulation. It got enjoined by the court in Massachusetts Fair Housing Center versus HUD. And then HUD has removed it and gone back to the earlier 2013 standard. It requires a three-part burden of proof analysis. Plaintiff has a burden of showing that a facially neutral policy or practice results in a disparate impact on a group of persons or creates, increases, reinforces, or perpetuates segregated housing patterns based on protected class categories. Second part, defendant has a burden to show a legally sufficient justification. And then the third part is plaintiff has to show that there's another practice that has a less discriminatory effects that serves the legitimate interest served by the policies. That's a standard 3 approach. Supreme Court in inclusive communities came up with kind of safeguards for disparate impact claims. I'm not going to go to too much detail on that now. The disparate impact is really based on an interplay between HUD's reinstated disparate impact rule and the Supreme Court's ICP decision. That's the standard for disparate impact liability. But let's look at disparate impact in appraisal discrimination cases. Courts have recognized that the disparate impact theory of liability applies to appraisal discrimination. There's a Hansen case. We're going to see a little bit more of that in a second. Tate Austin versus Miller is a recent one. The court there found plaintiffs sufficiently led a claim of disparate impact And because of that, the court said, no need to consider the disparate impact claim. I wish the court would have done that. Significantly, HUD does not mention disparate impact liability in the context of appraisal practices in the preamble to its original 2013 disparate impact rule back in 2013, or in its restated or reinstated disparate impact regulations in March 2023. I wish it did, but it doesn't. So Hansen, I come back to Hansen again, because it went to trial on an appraisal case. And the evidence is this. I'll go to the second paragraph. The first paragraph, just to have quoted here, is what they allege in their complaint. But here's a proof standard in the second paragraph. Appellants argue that the discriminatory effect of the VA appraisals is established by their statistical evidence. Again, they're using, this is Hansen. Hansen had disparate treatment and disparate impact. This is the part in Hansen's talking about disparate impact. The statistical evidence they presented is based on a comparison of facts surrounding the sales of homes in McGregor and Southampton subdivisions in which VA financing was sought. Appellants obtained the addresses of the homes being sold, the sale prices agreed to by the parties, and the VA appraised value of the home. Based on this information, the plaintiff's appellant's expert, Dr. Barton Smith, made computation which, he testified, revealed that the VA appraisals discriminated against prospective buyers and the sellers of the McGregor homes. He divided his samples into two periods, 1970 to 77 and 78 to 82. He found that 80% and 86% respectively of the McGregor homes were underappraised. The 80% figure was based on 24 samples and the 86% figure was based on 13. Smith found a 2% chance this many underappraisals would occur on a random basis. He concluded that the 4 samples in Southampton used for 1970 to 77 was too small to be reliable, but based on 7 sales in the 78 to 82 period, he found that 29% of VA appraisals in Southampton were under appraisals. He calculated that for that time period, the rate of appreciation of the values in McGregor was 6.8% and 15.7%, while the average appreciation rates for Houston was 11% and 13%. They said this unusual because McGregor was no longer experiencing the effects of the racial transition, which ended in 1970. He concluded that the homes in McGregor should have appreciated at the greater rate than the market generally because McGregor was recovering from deflationary forces such as panic selling that occurred during racial transition. So I don't know about that paragraph, but the fact of the matter is 80 and 86% of the McGregor homes were underappraised. That's pretty significant. But the Court of Appeals said, despite this evidence, the record supports the district court's decision to reject the various hypotheses and conclusions offered by the plaintiff's expert witnesses, right? And what the Veterans Administration expert said, Cook asserted that Smith failed to consider important non-racial variables such as crime rate and school quality in his regression analysis, although an earlier study Smith had done using the same SREA data found these variables to be contributing factors in the decrease of home prices. So it's tough, right? It's tough to establish appraisal discrimination even under disparate impact theory of liability. Old West End also had a disparate impact claim. In that case, this was not at a trial level. It was at summary judgment. The court said defendant Buckeye urges that plaintiffs have no admissible evidence of discriminatory effect. Plaintiffs, however, offered the affidavit of George Galster. Galster said, based on statistical evidence, that he's formed an opinion that there exists statistically significant differences between Buckeye's treatment of conventional mortgage applicants originating from white neighborhoods and Buckeye's treatment of similar applications from integrated or minority neighborhoods. That's dealing more with the differences in approval denial rates in minority, non-minority communities, not really directly, even though it's an appraisal case on disparate impact, the evidence is really not dealing specifically with appraisal practices. It's dealing overall loan approval denial rates. So tough. Interesting note, Fannie Mae's guidelines, which talk about fair lending in the appraisal process, and what lenders' responsibilities are to make sure there's fair lending in the appraisal process weakened. They've weakened over the years. In 2004, I dug it out and I thought, man, I wanted to use it in a case, and I thought, I can't find the language. I wanted the language in 2014. These actions may have a discriminatory effect. It was in the 2014 Fannie Mae guidelines, but by 2022, it had dropped out. In 2014, Fannie Mae wrote, use of unsupported assumptions, interjections of personal opinion, or perceptions about factors in the valuation process. These actions may have a discriminatory effect and may or may not affect the use and value of a property. And they list, again, the use of subjective terminology, pride of ownership, no pride of ownership, lack of pride of ownership, good neighborhood, poor neighborhood, crime-ridden area, desirable neighborhood, undesirable neighborhood. Those are kind of statements that can have an adverse discriminatory effect. By the time you get to the 2022 guidelines, it's dropped out and they completely removed it. Shame on Fannie Mae. That was very, very helpful. Certainly those kinds of things would have a discriminatory effect if in a minority community, appraiser regularly stated no pride of ownership, poor neighborhood, crime-ridden area, undesirable neighborhood location. What does that mean? Other than it's a generalization about a whole neighborhood or community. That will certainly result in the undervaluation of appraisals in that neighborhood or community. Common sense. But yet Fannie Mae pulled it out, and it's not by accident, right? It's a shame. Just a shame, right? Just to say, well, appraisers shouldn't say that. Okay, but if they do, you tell me. It should be liability for that. So where does the DI theory of liability as appraisal practice stand after the Supreme Court's decision in ICP? Some argued that the Supreme Court made two statements at the top on disparate impact. Two statements. First, an exemption from liability for real estate appraisers is in the same section as 805's prohibition of discriminatory practice in real estate related transactions, thus indicating Congress's recognition that disparate impact liability rolls under section 805. The Supreme Court in Inclusive Communities Project was decided or made a decision as to whether or not disparate impact theory of liability was available under the Fair Housing Act. Supreme Court reached the conclusion that yes, the Fair Housing Act does permit disparate impact claims. But there were three factors that they looked at. One factor in deciding that disparate impact could be available under the Fair Housing Act was the appraisal exemption of 42 United States Code section 3605C. And that's the first statement by the Supreme Court at the top. Then the second statement, Supreme Court said, if a real estate appraiser took into account a neighborhood schools, one could not say that the appraiser acted because of race. And by embedding 1305C's exemption in the statutory text, Congress ensured that disparate impact liability would not be allowed either. Some are taking these statements as raising an issue as to whether disparate impact liability can apply to appraisal practices. Again, in ICP, the Supreme Court relied on three exemptions in the 1980 amendments to the Fair Housing Act that assume existence of disparate impact claims, or as the court put it, would not make sense if the Fair Housing Act provided only for disparate treatment claims. They used the appraisal exemption, 3605C, and the exclusion of claims, 3607B4. Nothing in the Fair Housing Act prohibits conduct against a person because the person's been convicted of illegal manufacture or distribution of a controlled substance. Meaning, if they have a conviction on their record for legal manufacture or distribution of a controlled substance, then they can't bring a fair housing claim. And then 3607B4, nothing in the Fair Housing Act limits the applicability of any reasonable restrictions regarding the maximum number of occupants permitted to occupy a dwelling. So the Supreme Court said those exceptions kind of assume that disparate impact liability exists under the Fair Housing Act. Couple points. If you take the last two, there are still claims under 3607B4. Nobody reads 3607B4 is saying that that excludes disparate impact disparate impact claims involving criminal record policies? Obviously not. It just excludes certain people from bringing claims if they've been convicted of illegal manufacture distribution. It doesn't show that there's no disparate impact claims involving criminal record. Obviously not. And 3607B4, there are still claims being brought bringing disparate impact challenges to occupancy policies. All 3607B4 says that it doesn't limit the applicability of local building codes or building standards or occupancy standards, like square footage, number of persons to be occupy a unit. It doesn't, nothing in the Fair Housing Act limits the application of it. And so when I go to 350C, the appraisal exception has an appraisal exception as well. It doesn't have a wholesale exclusion of disparate impact liability when it comes to an appraisal exception. It doesn't. It doesn't exclude appraisal from it. A great example would be this, any kind of a scheme, where appraisal practices like reverse redlining when they're involved, and part of the whole reverse redlining scheme, or almost like a conspiracy, there's so many that are involved in it. Could be real estate agents, appraisers, lenders, and so forth. And part of that process involves overinflating appraisals, right? It doesn't, appraisal exemption, just because the appraiser doesn't mention race, color, religion, national origin, sex, handicap, or familial status, doesn't mean that they now cannot be liable under the Fair Housing Act. That's an overbroad reading of it. The text of the Fair Housing Act says nothing about, the appraisal exception says nothing about rejecting disparate impact claims. In fact, Congress, if wants to exclude disparate impact claims, it will do so specifically. It did it in the Genetic Information and Non-Discrimination Act of 2008. Congress expressly excluded disparate impact liability. And the legislative history makes, for the 88 amendments, makes no mention that disparate impact liability should not apply to appraisal practices. And HUD's implementing regulations pertaining to appraisals do not mention excluding disparate impact liability, nor is that mentioned in HUD's disparate impact regulations. Prior cases, no indication holding that appraisal practices are subject to challenge under disparate impact theory of liability wrongly decided. And it's an overreading of ICP. The statement that a real estate agent should be able to take into account a neighborhood schools without facing disparate impact liability is best read as an illustration of the appraisal exemption, not a broad conclusion that disparate impact liability never applies to appraisal practices. In ICP, the Texas Attorney General and District Court awarded points, or permitted the points to be awarded for units built in neighborhoods with good schools. And the court noted in ICP, in the context of the appraisal exemption, that appraisers could consider quality of schools without facing disparate impact liability. And reading ICP in context, it says this way. I think it's a better reading. If a real estate appraiser took into account a neighborhood schools, one could not say that the appraiser acted because of race, and by embedding 3605C exemption in the statutory text, Congress ensured that disparate impact liability would not be allowed either, and I'm adding this bracketed, if a real estate appraiser took into account a neighborhood schools. And the last thing is industry practice with appraisal practices permits appraisers to consider the quality of schools. So I don't think anything about, I just don't agree with ICP foreclosing disparate impact theory as to appraisal practices. So is a disparate impact claim presented in case study 2? With a prima facie case, what is the facially neutral policy? It involved, or again, there's no disparate impact in case study 1, so we're going to looking at case study 2. The facially neutral policy involves the refusal of the appraiser and lender to consider comparable sales within 12 months from cooperative B based on what reason? Historical valuations and requirement prior to late 2019 of cash purchases in cooperative unit A, and consideration of sales for cooperative A going back to 2003, according to the appraiser, or 2008, according to the lender, causing lower valuation of properties in cooperative A in comparison to cooperative B. That's the disparate impact, facially neutral policy. Instead of relying, the guidelines require that comparable sales be within 12 months. They shot way past that and went back beyond a year and went all the way back to 2003, believe it or not. Look at historical valuations. If you look at historical valuations of property, it's going to cause low valuations in minority communities, which just did here. Now, there's a question as to whether the facially neutral policy or practice actually predicted results in a disparate impact on a group of persons, or creates, increases, reinforces, perpetuates segregated housing patterns. In this one, it does result in a disparate impact, lower valuations of properties in cooperative A. The legally sufficient justification, it's unknown at this point what they're arguing on that. Identification of alternative practice, again, it's hard to, can't argue that. You don't, that's supposed to meet the legally sufficient justification, which hasn't been raised. One more thing, there are other theories of liability that apply in appraisal discrimination cases. There can be retaliation, 818 of the Fair Housing Act, 42 United States Code 3617. And the Sixth Circuit says deflating appraisals because of discriminatory animus. The Sixth Circuit said that that's an example of retaliation in violation of the Fair Housing Act. So here we're going to get to the nuts and bolts. All right, how are we going to gather the evidence of appraisal discrimination? You need to look at HMDA data, loan level data, and comparable file analysis. First off, Home Mortgage Disclosure Act, I'm not going to go through a lot of detail with it, but it requires, passed in 1975, requires lenders to publicly report certain information or data concerning their loan approval and denial rates. One of the purposes of it to see if lending institutions are meeting the credit needs of their communities where they're located, and target community development, investment, or disinvestment if that occurs. It also is designed to show instances of redlining, and it also promotes enforcement of the law, lending discrimination laws, including the Fair Housing Act and Equal Credit Opportunity Act. Like Equal Credit Opportunity Act, it's implemented by a regulation. This time it's Regulation C, and there's also staff commentary put up by the CFPB. Two things you want to look at. You want to look at for HMDA, Regulation C, staff commentary. There's also an annual guide to HMDA reporting. I use that a lot. The publicly available HMDA is located under the FFIEC website. I've got the reference there for it. This is an excerpt from the HMDA guide. It has the part on action taken data point, it's 10, and these are the various codes. The action was taken, loan originated, application denied is code 3, file can be closed for incompleteness, and so forth. That's important. Another one is property location. I need to use that, and it has various codes for that. I'll show you why in a second. And it has reasons for denial. When you're talking about appraisal discrimination, it's pretty much going to be a code 4 if loan is denied because of collateral. And that's column 26, so to speak. Now there's two parts of HMDA report. There's the public version. It will not list the loan application number. It won't list the date the application is received, and it won't list the date of the action taken. So I picked a sample one out. If you look at it there, it's missing the information. But on the far right hand, it has denial reason for. This example of a loan that is denied because of the collateral. You do not want a big stack of this loan application register in PDF format. Here, there's 4,634 pages. It's impossible to work with. This is the public version. The non-redacted, non-public version has the application or loan number. It shows the date the application is received, as the date of the action taken. And you can see everything else there is the same. And so that loan, as the number there, was denied for 4, inadequate collateral. So here's what happened. So for case study 2, I went to the FFIEC website. I downloaded the raw data. And what I did, it showed was a whole bunch of loans. So I went back and I took the property location. That's 13, 14, 15. I was able to figure out the coding for that. So if I go back over here, there's small vertical lines between the categories. So I needed to go to 13, 14, 15, figure out what those codes were for the particular census tract where the loan came from. And that's what I came up with. So I did that and I came up with 11 loans. And of those 11, I was able to identify which one was the case study 2 borrowers where they submitted their application. It took a little bit of time, then I could figure out this part of the coding has the loan amount and so forth. And the interesting thing is on the HMDA reporting, the lender reports it as a withdrawal rather than denied with the reason for denial as collateral. So there's nothing in the HMDA as reported by the lender which shows that the loan application was denied because of collateral. Yet clearly that's why the transaction failed. It failed because the bank came in with an $87,000 appraisal. So to me, this raises questions about what I can do with HMDA data. And if I get copies of the HMDA data from the lender, I'm not sure it's really going to provide the information that I need. Again, there's been consistent problems with HMDA reporting. You can't rely on it exclusively, right? Because it's often, the CFPB as enforcement, they enforce HMDA reporting. They only took 5 enforcement actions, right? 1 in 2020, 1 in 2019, 1 in 2017, 2 in 2013. In the 2020 enforcement action, they said the Bureau found that these data included significant errors, with some samples having error rates as high as 40%. And you see, the Bureau found Freedom reported inaccurate race, ethnicity, sex information, and that much of Freedom loan officers recording this information was intentional. For example, certain loan officers were told by managers or other loan officers that when applicants did not provide their race or ethnicity, they should select non-Hispanic white, regardless of whether that was accurate. See the problem, if they're turning somebody down, or just to be on the safe side, report it as white. Then if it's a denial, we don't have to worry about it. All right. So there's a problem with that. We have our office, there's commercial programs or commercial services that will provide HMDA data analysis. We have a subscription to lending patterns through Compliance Tech. Very, very helpful. I took the information from Compliance Tech and did the denial reasons based on the 2020 HMDA data. It shows there's a real problem in Detroit, Flint, Bay City, even Michigan as a whole, comparison to the US when it comes down to loans being denied because of collateral. In Detroit, it's 19.87%, in Flint, 18.24%. It's a problem. In Bay City, 19.44%, where collateral, inadequate collateral is listed as one of the reasons for loan denial. My recommended approach, strong recommended approach, is to obtain and analyze loan level data from an electronic database or Excel spreadsheet format. Here's how it works. This is developed from a HUD's Office of Systemic Investigation. It's very, very helpful, but this is the kind of data that you need to request. Electronic database. The first bullet point, the data items required to be reported by the Home Mortgage Disclosure Act. Where to go to put it down? Then identifying information needs to be put down. I should put down, well, I will do in a second. So then when it comes to borrower and property information, I've added a couple things. I added to it is the name of the appraiser and the name of the appraisal management company, if applicable. Want that information there. And you want, of course, to appraise home value and the purchase price of the home, if applicable. By asking for this, getting it in an electronic format in a big Excel spreadsheet, have a long way to send you a long way to be able to identify comparable files, and then provide a data dictionary for it. Here's an example of what the sample loan level data in Excel spreadsheet format will look like. I kind of, instead of going It's just too long. All these things go across in a long way in a big spreadsheet. But the sample loan level data has a loan number, application date, loan type, property type, loan purpose, owner occupancy, loan amount, pre-approval, action, whether it's originated, denied, approved, not accepted, and so forth, the action date. It has the MSA, MD area, state code, county code, applicant ethnicity and race, white, black, Hispanic. It has, Hispanic, Latino, has a race, has applicant gender, total income, type of purchaser, rate spread, and so forth. Then going down to the bottom, it has information on the property. And here's the crucial ones. It will show the appraised value of the home and the purchase price of the home. That will be reflected in the loan level data. And that has debt to income ratio, housing expense income ratio, and so forth. And those are all the things that you'll get in the sample loan level data. Very, very helpful. Why do I like that? Because just looking at the appraised value of the home and the purchase price of the home. The concern is that what? Maybe it's not reported in the formal HMDA reporting as being denied because the appraisal came in low and it's reported as a withdrawal. This will cut through that because it's going to show that the appraised value of the home ended up being below the purchase price. If you look at these right here, the first one is the purchase price home was 105. It got appraised at 107.5. That one, the appraised value is higher than the purchase price. The second one shows purchase price home 0 and the appraised value is $270,000. So what tells me there is probably could have been a refinance loan. I have to go back, probably a refinance loan. The same thing with the fourth one, probably a refinance loan. If I scroll back, it's going to have the purchase of it. And sure enough, that's what you see. Loan purpose for the second one is a refinance. And for the fourth one, it's a refinance. That's why there's no purchase price, because the home was being refinanced and there wasn't a purchase agreement. So to analyze it, here's what I would want to do. So I work with the loan level data. Turns out the beginning part is 18,351 loans. So I delete all entries with 0 or no appraisal. Why is it 0 or no appraisal? Some of them, many of them did not have appraisal requirement for the loan. So that's not good. So they need to be deleted out because those files don't bear on appraisal practices. And then I delete all entries with 0 for the purchase price of homes. And that gets resulting in 3,361 files. So what's happening at this time period? I guess there was a lot of refinances taking place. So I just picked Detroit, Flint, Ypsilanti, Auburn Hills, and Ann Arbor, just arbitrarily, just pick those communities. I could have picked any communities. So out there were 305 applications, 184 were from Detroit as a property city, 36 from Flint, 41 from Ypsilanti, 15 from Auburn Hills, and 29 from Ann Arbor. Now, what I did is I added a column after appraised home value and purchase price of home, and I entitled it Appraisal as Percentage of Purchase Price. And I put down an Excel formula, appraised value divided by purchase price, formatted it, then formatted it as a percentage. So then I sorted the appraisal as a percentage of a purchase price, and I deleted all that were less than 100% because, I'm sorry, I deleted all those, I think it should be more than 100%. I delete all those, meaning the appraisal came in over the purchase price. And so when I deleted all those where the appraised value came in below, so I deleted all those where the appraised value came in above the purchase price, ended up with just the files where the appraised value came in. And I'll fix this when I post a spreadsheet, when I post a slides on the video description. So it ended up with where appraisals came in below the contract price. There were 22 files, 14 in Detroit, 1 was originated, 1 was white, 1 from Flint, where there was 0 originated, 6 from Ypsilanti, 5 were originated, 4 white and 1 black or African-American applicant, and 1 from Auburn Hills, was not originated, and 0 from Ann Arbor. For all cities sorted by race where the appraised value is below the purchase price, there were 90 white applicants, 27 loans or 30% were originated, 15 Black or African Americans with 3 loans or 25% originated. I'm sorry, that should be 20%. 1 Native, Hawaiian or Pacific Islander, no loans originated, and 7 race not provided. So here's what I did. I put the percentages down here. For Detroit, there were 184 applications, 14 came in below purchase price. 1 loan was originated where appraisal came in below the purchase price, just 7.14%. But look, I was shocked with Flint. Flint had 36 applications where the appraisal came in below the purchase price. Right? There were overall 36 applications from Flint. 1 came in below the purchase price. In Ypsilanti, 6 came in out of 41, but yet 5 of them were originated. So it didn't matter in Ypsilanti for the most part. Auburn Hills had 15 applications, only 1 came in below the purchase price. Ann Arbor had no appraisals came in below the purchase price. So here's the percentage of when it comes appraisals below the purchase price. It has the applications and the appraisals that came in below the purchase price. Loans were originated where applications came in below the purchase price, and the percent of loans where loans originated where appraisals came in below the purchase price. So bottom line is this, looks like Detroit and Ypsilanti were the areas that had appraisals coming in below the purchase price. But here's the real key thing here. So I took the data and put it into a little spreadsheet here from Excel, eliminated some of the columns. And here's what I've got. So I've got Auburn Hills at the top. The purchase price home was 179. The home appraised at just 150. It was a purchase. That loan was denied. And it was a white applicant. And then the next one in the blue are the Detroit properties. See, it shows with Detroit, a number of sales appraised value came in below the contract price, and only 1 was originated. All the other ones were denied. Then Flint only had 1. I was shocked to see just 1. It came in below the purchase price and it was denied. It was a white applicant. And then at the bottom is Ypsilanti. And if you look at Ypsilanti, 6 came in below, 6 appraisal came in below the purchase price. And yet, right, 5 out of 6 were originated, and there were 4 white applicants who had their loans originated, even though the appraisal came in below the contract price. And 1 Black applicant had their loan originated, even though the appraisal came in below the purchase price. Very, very close though, right? 99.81%, close to 100%. And the only denial was a Black applicant who came in at below the purchase price, and they had their loans denied. And so what you do is they have the loan numbers on the left, and you can ask for copies of those files. And again, I just put together randomly in that. I don't have the data for case study 1. I don't have the data for case study 2. But if I was able to get the loan level data for case study 1 and case study 2, then I can come up with comparable files and do some analysis. My data doesn't have the name of the appraiser. It would be good to have the name of the appraiser and see what's taking place. It would be good to have the name of the appraisal company if there is one, and determine their liability. This is a way to show discrimination in the appraisal process. So what can you do with the data analysis on review of comparable files? Again, the appraiser, appraisal management company, lender issued low. You could show through this data that the appraiser, appraisal management company, or lender issued low appraisal to a plaintiff, but not to a comparable applicant of a contrasting protected class. You could also show that there's been denying an application due to a low appraisal while approving or originating loans for applicants of a contrasting class or in a contrasting non-minority community. You can also use it to show adverse treatment of applicants in majority minority community in comparison to majority non-minority community due to appraisal practices. For example, disproportionate percentages of for or collateral as reasons for loan denials. If I go back to my data here, you notice I'm missing a couple things on here. Pull it over here. I don't have, I'm sorry, right here. I don't have on here, I don't have the reasons for denials. Right, so I'd want that. I also want the name of the appraiser and I want the name of the appraisal management company. Once I have that, I have a pretty complete set of data and I'll get it in an Excel spreadsheet, and that could be really, really helpful in case study 1 and case study 2. And then I've been able to look at the comparable files that need to be produced and reviewed. If you can do that, right, you can satisfy the theories of liability, whether it's disparate treatment or disparate impact, and make a difference in terms of satisfying, right, the challenges, the enforcement, improving lending, improving appraisal discrimination. Anyways, in the chat, I'm going to go off recording in a second and answer the questions that are in the chat. Also, let me know any other training topics that are important that you would like to hear. I want to thank you for participating. I don't want to go beyond to our limit. Again, we're always available to answer questions. I hope this has been helpful to you. I hope it's kind of demystified some of the process. Again, I'm not here to replicate previous trainings. The goal is to get into the nuts and bolts of what can be done to show discrimination in the appraisal process. And obviously, you know what I'm driving at. I'm driving at getting loan level data to really be able to make those kinds of analysis and get the comparable files to show that there has been differential treatment when it based on race or other protected class category when it comes to appraisal practices. By getting that information, then we can start on a path to actually bringing meritorious claims and winning them in court. Right now, that has not occurred and has not been occurring. Without systematically going through and getting this kind of information, we're not going to be successful in appraisal discrimination cases. Anyways, I hope this has been helpful. Let me know. Again, feel free to reach out to our office if we can provide any other information, not only on appraisal discrimination, lending cases, or any other fair housing type of case. Thank you so much. And again, I look forward to seeing you again at future trainings. Thank you.